what they need to think about approaching the subject of taking care of a senior and assisting them with their needs. My name is Morris Sabbagh. I'm with the firm of Vishnick, McGovern, Belizio, and I've been practicing in the area of elder law and estate planning for over 25 years. And what I want to do today is talk to you about, as a caregiver, what role do you play, and who are all the professionals that you're going to be meeting up with, and how does the elder law attorney fit into that? And it's important because as a caregiver, you're going to be meeting up with a lot of different professionals. And those professionals include bankers and medical professionals and social workers, and all of this host of professionals that are there to help you, but also sometimes need more from you in terms of having the right documentation in place so that they can help you. Because all of these professionals are not only there to help you, but they are also gatekeepers to some extent. And there's good reason for that. We all know that there's a lot of elder abuse and a lot of elder fraud out there. And, the banking industry, the medical industry, all of the various industries that you're going to be dealing with are highly regulated now and have to be very careful about what kind of information they share and who they speak to with regard to the senior and the senior's needs. So you have to be prepared for all of that. And I think the prime thing that the prime role that the elder law attorney plays in that is to help you prepare to deal with all of the obstacles that you could potentially face in dealing with and assisting as a caregiver to a senior. And we all know it's not an easy job. We find that most of the people who are caregivers have many roles in life. They're mothers and fathers, they're sisters and brothers, they have jobs, they have full-time jobs, and they find themselves suddenly very often having to deal with not only their work and their immediate family, their children, but all of a sudden thrown into a role where they're taking care of a senior as well. And that's why very often we will refer to this generation as the sandwich generation, because they're sandwiched between their work and their family and the need to assist the senior in their life and help a parent that might have been taking care of them all their life, and all of a sudden they're the one stepping into the role of the caregiver. So what exactly is the role of an elder law attorney, and how does that elder law attorney fit in? Again, we want to prepare you to deal with the medical and the financial and the social changes that have to be addressed as a person ages, and the legal issues that come up in that regard. We want to plan for the need for medical care, which might not be immediate. In some cases it is immediate, and in other cases it's something that we're planning for in the future. And the possibility of a person becoming dependent, both physically dependent on caregivers, on home attendants, and the like. The inability possibly at some point in time that a senior will not be able to make medical decisions for themselves, an inability to make financial decisions for themselves. And of course, part of that, as anyone age, but at every age, we want to deal with the possibility of death and and dealing with estate planning issues as well. So how do you prepare, first of all? How does one prepare to meet with their elder law attorney? What documents should they have ready to show the elder law attorney? And how does that assist the elder law attorney to guide one in preparing for a senior's later years in life? Well, first of all, the elder law attorney wants to see all existing documents. So if the senior has a will, a healthcare proxy, a living will, a power of attorney, any trust that were ever set up, the elder law attorney is going to want to see what's already in place. Very important. Elder law attorney is also going to want to know about the assets and the liability that the senior has. Okay, so you want to compile, and this information is going to be necessary as you move along in taking care of the senior. If you need to step in the role of financial, writing checks for the senior, if you step into the role of having to deal with the financial advisor of the senior, you're going to need this information, okay? So you're not only preparing this for the elder law attorney to review, but you're also preparing all of this for yourself, so you familiarize yourself with what the assets are of the senior and what needs to be taken care of to organize that. So the types of things that you want to get together are deeds, stocks and bonds, if you have anything in certificate form. Most people do not have certificates these days, but we still find lots of older clients who do have, stocks, and they'll have, 20 different stocks in certificate form. And that makes it more difficult because in this day and age, dealing with transfer agents on those stocks does become difficult. Again, some of the regulations that have been put in place to deal with that make things difficult. If there are any business interests, not that doesn't usually come up as often, but sometimes you have a senior who does have operating businesses and the like. Any bank and brokerage statements, annuities, retirement accounts, life insurance, and long-term care insurance. So all of this should be compiled and reviewed. And part of what the elder law attorney is going to help you do is look at those assets and understand who has access to them currently. Are they joint? Is it just one person? Are they payable at death to someone? Is there anything that says automatically who those assets are going to in the event of death? Deeds might have a joint owner with right of survivorship. There might be a life estate. So there's all these things that you need to compile and might not be obvious to the layman. And then in some cases, you think that that the beneficiaries are all in place and, all the accounts have named beneficiaries or joint owners, and that's not always the case. It's very important to compile all of this and get an understanding of that and bring that to the elder law attorney, because that will help the elder law attorney to advise you with regard to all the myriad of types of areas of law that we deal with. And there are a whole bunch of those. And I'll talk about that. We also want to know about the family history. Are there children? Is this an individual who has no children and has no family? And that becomes complicated sometimes. Is there a spouse? Is this, were there any prior marriages? Do the children is the new spouse also the parent of the children? Sometimes these issues can complicate matters, especially where there are disputes or the children don't get along with a second or third spouse, and these types of things that come up, and we have to be prepared to deal with them. But of course, without advising the elder law attorney of these issues, they're not going to be able to guide you. Are there any pre or post-nuptial agreements in place? Again, with regard to the spouse issue, are there any, if there is a prior marriage, or are there any obligations to the prior spouse under any divorce decrees or separation agreements? What are the relationships among the family members? Do the children get along? Are there any outside parties that that are not family members that you want to take care of? Sometimes the children are not in the senior's life, and that becomes an issue. So this is, again, we need to know these things. Are there any circumstances, special circumstances with the family, within the family, or within the people that the senior wants to take care of that have special needs? So, for example, is there anybody with drug or alcohol dependence, any gambling or spending issues, How about special needs? Is there anybody who the senior wants to take care of upon death that is on Medicaid or have other special needs or is disabled? And then, of course, the other law attorney is going to want to know who are the trusted people in the senior's life. Okay, and that is for two purposes. One is for financial purposes, and the other is for medical and personal decisions. Okay, because again, there could come a time when the senior is no longer able to deal with their finances. That might be something very immediate, and that's something that has to be dealt with immediately. Or the senior does not able to make medical decisions, and that might be an immediate issue that needs to be dealt with. So once you get all this together, and these are all things that you want to be prepared to discuss with the elder law attorney. Now, what are some of the contingencies that we're trying to assist you to plan for? Well, again, I said medical decisions, right? And so we should know that as long as a senior is competent and is able to make their own medical decisions, they have the right to make their own medical decisions, and no one can take those decisions away from them. However, we do want to plan for a time if and when the senior cannot make those decisions. So how do we do that? One of the documents that you need to be aware of and prepared to sign if the senior does not already have it in place is a healthcare proxy. And basically what the healthcare proxy says that I am aware that as the senior, I'm aware that I'm in charge of my medical decisions. But I recognize that there could come a time when I cannot make those decisions, and I'm going to designate who can make those decisions on my behalf. And they will say in that healthcare proxy who those people are. And we usually recommend that you have, several originals of this document so that the person who is named, and usually we like to have at least one, if not two successors to that person, designated to make healthcare decisions in the event that the senior is not able to do that. And another thing that you should know is that typically you only want to put one person at a time. And the medical profession wants to see that for a good reason. If I have two people designated together on a healthcare proxy, then doctor goes to the two agents and says, okay, we have this situation. Should we or should we not proceed with this surgery or this procedure or whatever it might be? If Mr. A says yes and Mr. B says no, then the doctor doesn't really know who to listen to. So we want to make sure that we have one person at a time, and it's the most trusted people first. But also, that doesn't mean that they can't make decisions together and discuss it. It just means that if there is a conflict, there's going to be one person who's going to take precedent over the others in making those determinations. So that's one. Another thing that when it comes to healthcare, a couple of other things that help or could help in making healthcare decisions for somebody who eventually becomes incapacitated is a pulse. In some states it's called a pulse. In some states it's called a MOLST. And this is a document where this is actually not prepared with the elder law attorney, but a caregiver should be aware of it. It's prepared with the primary care physician, and the senior would go through a whole bunch of scenarios of situations and what their wishes would be in those situations, which really provides a guidance more specific than just, okay, this is my agent and this is who's going to make decisions for me in the event that I can't do that myself. And the other thing that, most people come to me and say, do I need to sign a DNR? And I think there's a little bit of misconception of what a DNR is. Typically, a DNR is a do not resuscitate order, is an order that's signed in the hospital by either the patient or by a caregiver in certain circumstances. And there's a whole list of priority of who can make these decisions. But a DNR is an order to withhold or withdraw life support in the event that a person becomes it needs resuscitation and wouldn't want that. There is, and that's usually in a hospital, there is something called a non-hospital DNR. And this is where somebody is really very ill, sometimes somebody who's in a hospice, home hospice, and their situation is that it does not make sense to resuscitate, and they can have a doctor sign a non-hospital DNR, which is just a one-page document that is filled out by the doctor and is kept by the bedside of the patient in case that any emergency medical is called, the EMT is called to the scene and to tell them that this person is not to be resuscitated. That's really the only document that EMT is permitted to follow in terms of a DNR. The other document that you should know about when it comes to medical decisions is a living will. And the living will, I like to tell people, the healthcare proxy deals with all kinds of situations. Admissions and discharges from hospitals, consultations with doctors and other medical professionals, access to medical records, and all these everyday medical things that have to be dealt with. And it comes a time when the person can't deal with those things themselves. There comes a time when the healthcare agent can step in. A living will deals specifically with the end-of-life decisions. And this is where the senior is going to state in writing, not everybody does this, but they can if they choose to, is going to state in writing that they want to designate what should be done in the event that they are either brain dead or terminal, not likely to recover, in the event that artificial means of resuscitation or nutritional feeding and the like are become required in order to keep them alive. And typically, it would be a document instead of a DNR. The living will is the document that would tell a hospital, if it was prepared in advance, that this is a person who did not want to be resuscitated. So that on the medical end, these are the documents that you want to consider. And then, of course, you also want to either within these documents or in a separate document have a HIPAA release, which will allow the caregiver to access medical records. And this is really important because there could come a time when the person is no longer capable of making their own decisions, but you need to prove that the person is not capable of making medical decisions for themselves. And in order to do that, you need access to medical records. And as we all know, under the HIPAA rules, and for good reason, people are limited in getting access to other people's medical records. So you want to have access to that. In order for the caregiver to have access to that, we want to have this HIPAA release form filled out. Then we move on to financial decisions and what documents will assist with making financial decisions. And the primary document here is a power of attorney. And there are different ways that a power of attorney can be set up. Power of attorney is a document where you say that I want my agent to be able to get records and deal with insurance companies and real estate and banking and all the other financial matters for me. And this can be set up either as a durable power of attorney that's effective immediately and stays in effect in the event that the senior becomes incapacitated and is no longer able to act, or what we call a springing power of attorney, which becomes effective in the event that the person can no longer make decisions. Now, power of attorney does not take away the right of the senior to sign for themselves, to deal with their own financial matters. It just adds someone in addition to themselves who can do that. And I think, among the documents that we prepare for people. I think the healthcare proxy and the power of attorney are sometimes the most important. And the reason is that sometimes we do encounter seniors who are hesitant about doing anything immediately that might be necessary in order to prepare for the financial needs of paying for health care in the future and what have you. And if you have a health care proxy and a power of attorney in place, that allows the person in the event, that allows the caregiver in the event that this senior becomes incapacitated at some time to still, plan on behalf of the senior if the senior failed to do a full plan for themselves. And part of that in New York is that this power of attorney should also have a statutory gifts rider, which allows for the agent that's named to set up trusts and to do gifting and transfers in case that's necessary, either for tax planning purposes or for purposes of Medicaid planning and the like. And I mentioned the durable power of attorney. I just want to go back. The other type of power of attorney is a springing power of attorney, and that's one that is only effective and can only be used in the event that the senior becomes incapacitated. Another document that, other types of documents that come into play when we're talking about financial issues are trusts, revocable and irrevocable trusts. Revocable trusts are more similar to the power of attorney, set up for purposes of assisting the senior in later life to deal with their finances in the event become incapacitated and someone needs to step in. It's a lot easier to do that when you have a revocable trust in place rather than just the power of attorney. It's also used for probate avoidance, which means that you're trying to avoid the process of taking a will to the courts after a person dies and having to probate that will. And there are a whole host of reasons why, sometimes if there's likelihood of a will contest, revocable trust is a good vehicle to avoid that. And these are all things, again, that the elder law attorney is going to guide you on. There's no two situations are the same. Different people need different things. And again, the elder law attorney is the one who should be guiding you on this, because you are going to deal with medical professionals and social workers and bankers and all these other professionals that will only have part of the picture. So they might be able to guide you a little, but they're not going to be able to give you a full picture of what should be done, because they might not know the other part of the picture. I can be dealing with somebody, a senior who has several millions of dollars, and Medicaid planning is just not the right thing. But the medical professional, the social worker, is not going to know that. They're just not in the position to know that, because they don't have a full all the information they would need in order to guide the social worker, to guide the senior or the caregiver in making the right decisions. And which is why very often you see that they will refer a person to speak to an elder law attorney. What is an irrevocable trust? So an irrevocable trust is usually set up for purposes of either tax planning or Medicaid planning. And I'll talk a little bit more about both of these in a couple of minutes. But in an irrevocable trust means that it cannot be changed. It cannot be taken back, right? So before a senior wants to do something like that and make a decision where they're putting their assets out of their control permanently, there has to be a good reason to do that. And there are a lot of good reasons for that, and depending on the amount of wealth of the senior and how they're going to pay for their medical care in the future, in case they need home attendance or nursing home care, that will determine whether or not an irrevocable trust is something that's necessary. And with all of these vehicles, whether we're dealing with a will or revocable trust or an irrevocable trust, the other issues that come up that we have to deal with are issues within the family. Are there any family disputes that we have to think about? Are there any special needs family member issues that we need to think about? And all these have to be considered and dealt with in either a will and or the irrevocable trust, revocable trust. And so these have things that other things that we come across that have to be dealt with is creditor protection for both for the elder and for the beneficiaries, and protecting from outlaws. We have lots of our clients come in, seniors say, well, I want to take care of my children, but I'm concerned about how they might be influenced by their spouses, or I don't want their spouses to end up with the money and all these things. And these are, again, issues that have to be dealt with and discussed when you have that meeting with the elder law attorney, so they know to address that in your documents. Estate taxes, again, something that we'll talk about in a few minutes. When in terms of elder fraud and fraud on elders, we're seeing a lot of problems out there with, seniors that are getting phone calls from people saying they're from the IRS or from Social Security, or calling to get phony charitable contributions. People who also sometimes become close to a senior and manage to convince them to give away assets or to what they shouldn't be doing. So this is a big concern, something that FINRA, which is the agency of the federal government that deals with banking, about 3 years ago, instituted something called the trusted contact person. And this is something that most people don't know and aren't aware of, but it's something that when you're dealing with brokers, where you have stocks and bonds and other things in an account or bank accounts, there is the ability to put on the account a trusted contact person. So if the banker or the financial advisor suspects that something's fishy and, hey, we better look into this, there's somebody that's already designated a trusted that can be called. And so that's something that a caregiver should know about when dealing with the elder law attorney and with the bankers and with the financial advisors, to put them on notice, hey, I want to make sure that, and a lot of times our seniors come to us and say, I know that I have either early Alzheimer's or some other issue that concerns me, and I'm afraid that somebody could take advantage of me, and I want to make sure that, somebody's looking out for me. So this is something that can be done, and especially, I had a call last week where we did all the right planning, but the senior was concerned that they're starting to their judgment might be waning a little bit, and he wanted to make sure that his IRA account was protected. Now, you could have a power of attorney and all these things on your IRA, but you can't really put it into a trust. So we need to have that extra step, extra protection. So what we suggested there is, hey, contact the financial advisor and speak to them about, putting a trusted contact person on the account. So these are some of the things that we deal with, again, that you should know about, and that you should be prepared to talk to about with the elder law attorney. Now, let's talk about a little bit about the estate tax laws, what the current law is, and what we anticipate could happen, depending on what happens with the upcoming elections. So currently, for many seniors, estate taxes are not an issue. And the reason is that the current exemptions are rather high relative to what they were many years ago. Currently, the federal estate tax exemption, that's the amount that can pass to family members. Now, between spouses, There's no tax as long as both spouses are U.S. Citizens. But in terms of giving to other family members or friends or anybody outside of the spouses, we have a federal exemption, and currently the federal exemption for each person is $11,580,000. That means that at death or during life, that amount can be passed on to others without a federal estate tax. And again, it's pretty, for most people, it's a pretty high number, especially when we're dealing with seniors and planning for Medicaid and the like. The New York State exemption is lower, but also relative to what it was historically is kind of high, and that amount is $5,850,000. A lot of people are aware of what used to be a $10,000 annual exclusion. There was the $10,000 that you can give to each person, whether it be a child, a grandchild, a friend. You can give tax-free every year. It used to be $10,000. Now it's $15,000 that a person could give tax-free. And that's the annual exclusion. That's in addition to these exemptions that I'm talking about, right? So every year, if I have 10 people I'm giving to, I can give $15,000 to each of them. That's $150,000, and that's not going to be charged against these exemptions that I'm talking about. So again, for most, and and that's why, because people are aware of the historic gift tax laws and the estate tax laws and the 10,000, people get a little bit confused. But for most people, you know, that's one of the things that they come in to talk about in terms of, well, what are the tax issues I have to be concerned about? And typically, in most situations, the estate tax or the gift tax is not going to be a major issue. What will be a major issue for a lot of people is capital gains tax, especially with regard to real estate, especially with regard to, in most cases, when we are doing planning for Medicaid planning or for any elder, whether it be tax planning or otherwise, we're dealing with a house that might have increased in value substantially since it was purchased, and we're concerned about capital gains tax. And there are laws that that provide, so for example, there's a law that if per spouse who own and live in a house for 2 out of 5 years prior to a sale, you have a $250,000 exemption. For 2 spouses, it would be a $500,000 exemption on the sale of the house during lifetime. So that's something that you need to know about. You don't want to just go and transfer a property into your child's name and find out later on that, hey, I made a mistake, because that child's not going to have those exemptions if the house is sold during my lifetime, and they're not going to have the exemptions at my death. You know, so you need to talk about these tax issues as well with an elder law attorney when you are doing any kind of transfers, to make sure that you are preserving that exemption and that you're preserving something called the step up in basis in property. And the step up in basis in property is, first you have to understand what the basis in property, your basis in real property is. Your basis is the amount, typically for most people, it's the amount that they pay for the property, including improvements. So if I sell for $800,000 and I paid $500,000 between the original purchase price and improvement, so that I have $300,000 capital gain, and my basis is the $500 that I invested. And again, if it's the primary residence of the senior, or the senior and the spouse, then I might have a $250,000 or $500,000 exemption to use against that. When we talk about basis at death and the step up in basis at death, that number, what we're saying is that when someone inherits a piece of property, and under current law, they get a new basis. So the child, for example, who inherits a house that had a $500,000 basis that the parent invested, when they inherit that property and it's worth $800,000, the child or this other inheritor gets a new basis. That new basis is the value at death, that $800,000. So therefore, the child or other person who's inheriting the property can sell for $800,000 without paying capital gains tax. So that's a very, very valuable thing that needs to be considered. And when we either transfer, one of the reasons why we use trusts, and if it's designed properly, and if you're doing any kind of Medicaid type planning or any kind of planning dealing with a house or any property that's grown in value and has a capital gain, before you fund the trust, make sure that the elder estate law attorney, estate planning attorney, discusses with you the tax ramifications, and have they made sure in the trust that they've preserved this the step up in basis that I just talked about, and the lifetime exemption of $250,000 to $500,000 that I talked about. These are things that can be done. It can be designed properly, and if designed properly, you can preserve that even in situations where the property is being given away. So when do we typically find that we're giving away property? Again, usually that is, and we're setting up trust and the like, usually that's either because we're doing tax planning and the person has more than these exemptions that I talked about, the New York exemption of $5,850,000, or the federal exemption of $11,580,000, or we might be, or in the more common situation these days, we're doing planning for Medicaid. We need to understand, why do people plan? What is Medicaid planning, and why do people plan for Medicaid eligibility? So first of all, what we need to understand is that there's only three main ways that long-term care is paid for, okay? First of all, we understand that Medicare, if somebody has Medicare, Medicare is not going to pay for long-term care. They're not going to pay for somebody who, for the rest of their life, is going to need either home attendant services or nursing home care. Medicaid is there to provide support in the event that there's a rehabilitation need, to get somebody back to their healthy self. But it's not there for ongoing supervision or care. So Medicare is not an option. So we have to look, what are the other options? And primarily there are three sources of payment for home care and for nursing home care. And those are either self-pay, privately paying out of pocket, or you have long-term care insurance, or you are getting care through Medicaid, and Medicaid is footing the bill. There are also, certain VA benefits that provide assistance, but for the most part, these three are the primary sources of payment for care. Now, the elder law attorney, once you go through all the assets with him or her, is going to guide you and say, okay, you fall more, either you have, plenty of assets and you're never going to qualify for Medicaid, or you have a lot of income from a pension or whatever, and you're not going to qualify, and therefore let's plan otherwise. Let's plan and figure out how you're going to privately pay. If you go to the elder law attorney early enough and they find that Medicaid planning is not the right thing for you, or you're not comfortable with giving away assets, then they might suggest long-term care insurance. But obviously, you still have to be well enough and at an age that you can qualify for that. And then the third, we said, is Medicaid. But understand that Medicaid is a federal program. It's run by the states, but it is a federal program, and it's designed for people who are impoverished. So originally designed for people who do not have assets and have low income. When we're talking about seniors, for people who are younger, the rules are different. But when we're talking about seniors, they're going to look at both assets and income. And just for example, somebody who's living at home and not married, they're only allowed to have about a little bit less than $16,000 in assets and be on Medicaid. Now, there are certain exemptions for the house that I'm not going to go into, but typically when we do Medicaid planning, we're also planning to transfer the house out of the name because there are recovery rules, and even if it's an exempt asset, there is a possibility that Medicaid can recover against the house after death. So Medicaid planning usually does include making a transfer of a home as well as other assets. But we also need to look at income, and the income limits are quite low. And typically, if somebody's over the income limits, they will have to either spend that towards their care or use certain other types of trust that an elder law attorney can guide you on, such as a pool trust, if they're living at home. And then there's a whole group of rules that deal with what happens if there's a spouse who's living at home and one spouse is in the nursing home, and there's some added protection for those people. Okay. Now, when we're talking about Medicaid planning, you're usually talking about disposing of assets for purposes of getting down to these asset limits that we're talking about. Now, first of all, most people are familiar that there is a 5-year look back, meaning that if someone gives away assets in order to qualify for Medicaid, Medicaid is going to look back 5 years and to see all the transfers that might have been made during that time period and penalize the person for those transfers and say, well, because you made that transfer, you're not going to be eligible for Medicaid for a certain number of months. And typically downstate, here on Long Island and in the city, you're looking at somewhere between 1 month penalty for every $12,000 to $13,000 that was transferred. One thing that if there is an emergency situation and the senior needs immediate nursing home care and is well over resourced, sometimes planning can be done to get them qualified prior to the full 5 years. And there are techniques that are used to do that, involving gifting and promissory notes that I'm not going to get into, but these are things that just be important for a caregiver to be aware that, just because mom or dad or the person you're caring for, is well over resourced, doesn't mean that there's nothing that can be done. It's important to discuss the finances with the elder law attorney and see what can be done, because there is often a lot that can be done, and possibly the ability to get nursing home qualification a lot sooner. Now, until this year, New York State had a really great program. When we talk about institutional care, we're talking about nursing home care. When we're talking about community Medicaid, we're talking about care at home, getting a home attendant and nurses at home. And typically with community care in New York, the program was very lenient in terms of these penalties, because historically there was no penalty for getting community Medicaid care at home, even if someone transferred assets. So very often the elder law attorney had no problem. You go in, you discuss the assets. Assets could be transferred out, whether into a trust or outright, and qualify the following month for Medicaid in the community. But that's going to change. The most recent budget earlier this year was passed, and now we have a 2.5-year look back for community Medicaid, meaning that when a person applies for community Medicaid, they're going to look back, and they're going to look for the 30 months prior to the application and see were any transfer made. And penalize a certain number of months. Now, it's not clear how this is going to be done yet because there's really nothing in writing at this time. A lot of what we know is only by word of mouth between the Department of Health and elder law attorneys who have spoken with them. So there's nothing, there's no black and white rules here on this. We're going on what we know, and we update it as we find out more. What we do know was that originally they only will penalize people who made transfers after October 1st of this year. So if you made transfers prior to that, those are not going to be penalized for community Medicaid. They still possibly will for institutional Medicaid if it's within the 5-year look-back period. Originally, it was supposed to be implemented October, and then they moved it to January 1st. And now they're looking at an implementation probably somewhere around April 1st. And this is all due to COVID-19 and not changing the Medicaid rules in the interim. So what we believe is going to happen is starting April 1st, if there was a transfer after October 1st, on a community Medicaid application, there will be a potential penalty, and they will look at that and penalize those transfers. But we don't know very much. I don't want to get too much into pool trust because that's a whole subject in itself, but we believe that pool trusts are still going to be available for for purposes of community Medicaid qualification. So, you know, that's pretty much a lot of what I wanted to talk about, but I do want to leave some time for Q&A. So I'm going to get back to Mallory and, you know, we can answer some questions.
Yes, thank you so much, Morris, for that wonderful, wonderful presentation. Such, you know, packed with vital information for the caregivers. So thank you so much. And also thank you, Roy Schwartz, for helping me put this together also as well. So yes, we would definitely like to leave some time for some Q&As. I do have a question here for caregivers or anyone that has any questions. You could go ahead and submit your questions in a group chat, or if it's okay, you can unmute yourself and ask the question as well. Ask Morris your question. But there is a question submitted here in the group chat. It's kind of long, so bear with me. It says, we are 3 siblings. My brother is on Medicaid in Florida, and he does not want to lose he does not want to lose it if me or my sister pass and leave him anything. My sister doesn't want to waste money putting a trust for him and keeps procrastinating to make a will, etc. Can my brother protect himself from his end to have a legal document stating that he does not want anything from us, or just her, as I have my paperwork, I just need to update it?
Yeah, I mean, that's actually a kind of a difficult situation, because if your sister doesn't do the proper planning and your brother does inherit, there's not a lot that can be done. He might be, depending on his age, he might be able to do what we call the self-settled supplemental needs trust at that point, and put those inherited assets into that self-settled supplemental needs trust, if he's under 65 at the time. But in the better route, and what you should know is, or your sister should know is, I know she's hesitant to go ahead and write a will, but she should know that the trust for, if she was going to set up a supplemental needs trust for your brother, she can do that in her will. So she doesn't have to be done in a separate document, and that can be put and implemented through her will. So hopefully that'll make it easier to swallow.
And she also asked, if the person gets a $15,000 as a gift, do they claim it as an income or have to pay tax on it?
Yeah, the annual exclusion gift is a gift. If it's not considered income.
I also have another question here that was submitted. She said that he is 75.
He's 75. Okay, so then the self-settled trust is not an option, but it's really important for your sister to set up that will and do a supplemental needs trust.
Okay, awesome. Thank you for that. I have another question here. Could you give more information on living wills?
Okay. So again, the living will, the purpose of the living will is to state in writing what the person's wishes are about withholding or withdrawing life support. Okay. In the typical situation, most people are saying in a living will that they do not. And, we've had so many people who've been through this with a loved one. They've watched them suffer and sometimes be on mechanical respiration for long periods of time, and they just don't want to go through that themselves. And very, very often, when we're talking about a living will, they're saying in writing that they don't want that. But a living will does not necessarily have to say that. Sometimes a living will might express religious beliefs and might specifically state that the person does positively want to be kept alive in certain circumstances and the like. But again, this is a document that should be prepared in advance. Even young people should have it. I always say that all the major cases, if you remember years ago, the Terry Chavo case, and the cases before that went to the Supreme Court, a lot of these people were in their 20s and 30s. So it's something that people should think about at every age. But certainly seniors should have that in advance, well before they start to lose capacity.
Okay, perfect. Thank you for that. If anyone else has any questions, you could go ahead and, they said thank you. You could go ahead and submit that in the chat box, or you could unmute yourself and ask your question, okay? Does anyone else have any questions?
Yes, I have a question. What happens if you have none of the above and the person that you're taking care of, her memory is already kind of lost? And I started off this process with my mom in South Carolina, and I brought her here last year. All I have is a power of attorney from South Carolina, but she's not willing to do anything else since she's been here.
Okay, so it's a great question. I addressed that slightly earlier, but I'll go into a little bit more. So first of all, we want to address your mother's capacity, right? Mm-hmm. So, and that's why the attorney will assist in doing that. And, the capacity to make a will is lower than the capacity to do some of these other things, like set up a trust. But typically, the capacity to make a will, the person has to know who the natural objects of their bounty are, meaning who's their family members who would normally get their assets if they had no will, and more or less what their assets are. They shouldn't think that they're a billionaire and their own, and then they have $10,000 in the bank, obviously. But so it's possible that she could still have capacity. Okay. If she doesn't have capacity, then we want to look at that power of attorney that you have, okay, and see how thorough that power of attorney is. Does it allow for you to do estate planning for her? Can you do gifting? Can you set up trusts? Okay. As a worst case scenario, then if the documents that you have in place do not allow you to do that, you could potentially be looking at a guardianship. And guardianship is, I didn't really get into it, but guardianship is really what we're trying to avoid when we have all these documents in place. Right? Because if you have a power of attorney to deal with financial matters, and you have a healthcare proxy, and you have a living will to deal with all these situations, then there should never be a need for a guardianship. But when we do come into those situations where guardianship, where the documents are not in place, then that's when we need to look at guardianship. And the reason we don't like guardianship is they're expensive. They're very, they involve the courts to a great extent, and they they take a long time to get through sometimes.
Okay. Thank you.
All right, so I do have another question here that was submitted. In a will, do you only use percentages, or can you put give Sally $10,000 or Mary $5,000, or do you only use percentages of what's left, as my sister cannot make up her mind with percentages, but she will say, give so-and-so 10,000 if I die?
Okay, so there are a few different kinds of bequests. We call them specific bequests, general bequest, and residuary bequest. A specific bequest is a specific asset. I want to give my car to my sister. You know, I want to give my, you know, my favorite necklace to, you know, my friend, whoever it is. So that's a specific bequest. Then you have a general bequest, which is a dollar amount. Okay, giving $10,000 to this person, $5,000 to that person. Those are all general bequests. But then you have everything that's left after you made those bequests, right? So if I didn't give it all away, then you're getting into a percentage. Who does everything else go to? You never want to leave that out, because if you made $100,000 worth of bequests and you have 150, who's that extra 50 going to? And that's what we call the residuary bequest. And that residuary bequest could go 100% to one person or a charity or whatever, or it can be divided up by percentages. But you never want to leave out that last residuary part. It's very important.
All right, thank you for that, Morris. So we only have one more time. We only have time for one more question. Does anybody else have a question that they would like to ask Morris before we end the program? You can either unmute yourself or submit it in the group chat. Yes. So we did so we have a question about the recording. So we did record it, and we will send that copy to Roy Schwartz, and he will be emailing that out to everyone. Awesome.
Right.
All right. So I think that's it for today. Morris Sabbagh, thank you so much for doing this caregiver webinar for us. Roy Schwartz, thank you so much for putting this all together for our caregivers and everyone else who joined in. Thank you so much. Again, my name is Mallory Debuson, Education Training Specialist here at Parker Jewish Institute. We provide free support and resources to caregivers caring for a loved one with Alzheimer's disease and or other dementias. Thank you so much for tuning in. Morris, thank you so much. Roy, thank you.
Thank you, Mallory.
And everyone, have a wonderful, amazing afternoon, even on a rainy day. All right, everyone, goodbye. Thank you.
Okay, bye.